The Honorable Justices of the Supreme Court, hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh, to give their attention to the court. Now sitting.
Please be seated. Good morning. Excuse me, my chair is stuck. It's off the pad. These are quite heavy but comfortable. So it is really great to see so many of you in the courtroom today. Mr. Skeens, we're excited to welcome your class back to our courtroom. Would you like to come to the podium and introduce yourself and explain your program?
Morning. May it please the court, Madam Chief Justice, esteemed members of the court. My name is Alan Skeens, and I'm here today with my students. This is my law and public safety class. We are from Blue Valley CAP School. The CAP stands for Center for Advanced Professional Studies, and we're over in Overland Park. And we like to come up every year, and we've missed the last couple of years, so we appreciate the opportunity to be here this morning.
Thank you very much.
Thank
Good
you.
to see you. So we'll do a real quick survey here. After almost a complete semester of the program, are you still interested in a career in the law? Yes, I'm saying enthusiastic nods. But we'll hope we don't change that for you this morning. So,
Madam Chief Justice,
Yeah.
may I say that all my kids went to Blue Valley High Schools. So a special welcome. I live in the Blue Valley School District right now. So a special welcome from me.
and I assume the students probably know that I am the mother of a CAPS teacher, instructor, just down the hallway from your classroom. My daughter teaches, and so I'm very familiar with the program and very enthused about the program, its goals and its mission. So I'm glad to have all of you participating in that. With that, Mr. Shima, would you please call the first case on the morning docket?
The first case on the docket for Tuesday, March 29th, 2022 is appeal number 121503, State of Kansas versus Michael Glenn Molyneux, Geary County, briefs both sides.
Council, would you please come to the lectern and enter your appearances? Chairs are a problem this morning.
May it please the court, Patrick Dunn, Deputy Appellate Defender, here today on behalf of Mr. Molyneux. And I don't know if you'd like me to ask to reserve time now or when I
Either
begin.
way is fine. I'll make a
May I
note.
please have 2 minutes for rebuttal?
2 minutes is granted.
Please the court, Tony Cruz, Assistant Geary County Attorney representing the state of Kansas, ready for argument.
Done. Whenever you're settled and ready, you may begin your argument.
May it please the court, again, Patrick Dunn, here today on behalf of Mr. Molyneux. At the outset, my wife is a teacher in the Blue Valley District, a middle school Spanish teacher, and just asks none of the students or their parents hold anything I say against her. So the first thing we need to recognize here is this is a simple case. June of 2018, Mr. Molyneux was arrested on a traffic violation, and during a search incident to arrest, the officer found a marijuana pipe in his pocket. Based on the residue in that pipe, the state charged Mr. Molyneux with felony possession of marijuana and also with the possession of the paraphernalia, misdemeanor possession of paraphernalia. He immediately files a discovery request it's actually an agreement of the state's making 2 days after his arrest. So things move along right before trial. It's the week before trial is scheduled. Counsel goes to look for the KBI lab report, which purportedly finds THC in the pipe, and it's nowhere to be found. In the past, the state has said, well, you need to come physically look at the file. So counsel goes, looks at the file. It's not there. Following day, files a motion to dismiss. And the next business day is the Monday of trial.
Can I ask just a procedural or kind of a question regarding the report in question here? There were 2 preliminary hearings in this case, wasn't there?
That's correct.
And in both preliminary hearings, the state had the report and introduced it as evidence. Is that correct?
That's correct.
And at the time that exhibit was introduced into evidence at both preliminary hearings, did defense counsel have access to it and see it and look at it and an opportunity to cross-examine the witness who provided the report?
Yes, and as Ms. Cabrera, the trial counsel below said, at that point, she's not looking to thoroughly.
No, I
for the
understand,
contents of it.
but there was access to the report, at least at the preliminary hearings in this case.
For moments.
I understand. I know how all that works. It wasn't like a mystery that it was
Sure.
a phantom report or anything like that. It was physically there at some point.
Sure, and I would point out that Ms. Cabrera did want to cross-examine on some other things, and the magistrate refused to let her and narrowed her cross-examination. So this wasn't a situation where she could just run amok and ask whatever she wanted. She had all the time in the world. So I'm not sure. The other important aspect, as you brought up the preliminary hearings, is what wasn't admitted, the pipe. So we don't know. Defense counsel's never had a chance to see the pipe, to know what this residue really was, how much was there. And as we know, and I'll talk about later, knowledge is an essential element of possession. So one might think they have a pipe and not know that they have possession of THC in there, and that's a very valid defense in the state of Kansas. So with that, I want to briefly.
One other point for clarification is the Court of Appeals commented that they saw no connection between the 2 preliminaries and the issue before the court. But it seems there may be a connection because, as I understand it, there was a problem with production of a different report, the journal entry at the preliminary hearing. Am I accurate in that?
Correct.
So the state was missing a document at that point that hadn't been produced for the defense?
Correct.
Okay,
And
recitation.
defense counsel, I believe, and the wording of this in the transcript is a little unclear to me. And I initially interpreted it as the state said, if we don't have it in our file, we don't have it. You've got everything we've got. And that wasn't the case. And I wasn't sure in reading that if that was to the KBI lab report or just the journal entry or both or one or the other. So I just wanted to clarify. I'm not completely sure upon rereading it in preparation for today of that.
Counsel, can I just ask a procedural question? I'm sorry. And when the document was admitted at the preliminary hearing, did the court reporter keep a copy of the document? Was it withdrawn by the state and kept by the state?
I believe it was withdrawn by the state. Okay. Ready for issue 1? All right. And I don't want to spend a lot of time on this, but procedurally, I think the Court of Appeals has fundamentally misinterpreted what's gone on in this case. The discovery sanction in this case was exclusion of the lab report and any KBI testimony regarding the contents of that report. That wasn't appealed. The notice of appeal was strictly limited to whether or not the district court erred in dismissing the case with prejudice. That was a separate motion. The initial motion was about the exclusion, and there was no revision to the district court's decision. That was the question of whether it was dismissed with or without prejudice had to do with basically would the initial decision ruling, the initial sanction, be enforceable. So that's not before the court. The decision of whether or not there was a discovery violation, that's settled. It's not the subject to appeal. So that is the main thing. I wanted to point out in issue 1, had the state wanted to appeal that, they could have filed an interlocutory appeal under 223603. They didn't. This is an appeal from a dismissal under 223602B1.
So to put that in a technical term, would your argument be that it is the law of the case that the court is excluded?
Yes, and in the court's language, it is deemed waived and abandoned because it was not raised below and
And I
preserved.
understand that part. Well, I'm need to understand a little better why you characterize isn't the district court's decision to dismiss with prejudice also considered as a sanction against the state? Because kind of characterize that as a sanction to exclude the report. And I understand that we've got a bucket that's exclusion of the lab report. They didn't appeal that. The other bucket is the dismissal with prejudice. But don't we consider whether the district court abused its discretion in dismissing with prejudice with the idea that that's part of the sanction for the failure to discover? Because I understood your argument to be, if we don't dismiss with prejudice, they're just going to do it again. Some other, they're not.
No, they're going to do it. They're going to do it in this
They're
case.
going to do it in this case.
They said that's what their plan was.
Right, but there's no deterrent in effect without the dismissal with prejudice. To me, that seems like.
It's not the deterrent I'm talking about.
Okay, go ahead.
I'm talking about there is no exclusion. The ruling is there is exclusion. Now, it has to be enforced somehow. Now, either we go ahead and the trial goes forward. And again, fundamental problem, I think the state perhaps didn't understand what it was allowed to do is you can try a possession case on circumstantial evidence. There's absolutely no requirement. All cases can be tried on circumstantial evidence. There is no statutory case law requirement, anything that says you have to have a KBI lab report. Sure, it makes your case easier, but that's not required. The state somehow seemed to think it had to have this. Now, not the case. So exclusion was the decision. So if you allow the court, if you allow the state to have its motion to dismiss, and that was who raised it. It was the state said, okay, I understand your ruling. I move to dismiss the case. If you allow them to do that, then there's no ruling at all. It's meaningless.
Is there another alternative that would have accomplished the same thing? Short of dismissal with prejudice?
I can't think of one.
Well, why wouldn't the court just say your motion to dismiss is denied?
Could have done that.
Well, that's the alternative, right?
Oh, yeah, I guess that is. I hadn't thought about that. Sure.
And so why should the state be penalized because the district court didn't do what it should have done from your perspective? Which
Because it
is
was the state's request to dismiss the case.
not to dismiss with prejudice, though.
At that point, once they had raised the issue, they didn't argue, the state never retracted its motion to dismiss. If the state wanted to proceed, they could have said, okay, we withdraw that.
Well, but was that?
I don't see why
motion-
this is pushed on defense counsel. They were blameless in this.
But let me ask a clarifying question. My understanding is the state's motion to dismiss was to dismiss without prejudice.
That was correct.
And so there was an adverse ruling against the state, even though the issue was presented to the court in the state's motion. The court did exactly the opposite of what the state was asking.
I don't think they did the opposite. They took a twist on it, is what I think. And again, and I think we also need to,
And that's the ruling as I understood your argument, that's the only ruling that is before us on appeal.
that is the only ruling before you. And I think the other thing we need to remember is the standard review on dismissing with prejudice,
And I guess the
which is
question-
abuse of discretion.
Right.
And you may not have done that. And Judge Atchison pointedly notes he wouldn't have done that,
Why isn't
but that's a standard of review.
Why isn't it a mistake of law, though? I mean, what legal grounds exist for a district court to dismiss this case with prejudice?
There are no legal grounds that he can't. She couldn't. It was a she, I'm sorry, Courtney Bohm. There is absolutely nothing. The statute that we're talking about, and this court has recently said, we care about statutes. It is a valid discovery sanction to exclude evidence. We all can agree upon that. It is plain as day in the statute. That is one of the statutorily authorized remedies, and that is the statutorily authorized remedy the district court granted. Now, after that's granted, the question of dismissal with prejudice, that's a totally different question. That's not a discovery question anymore. We're past discovery now. Now we're at the point of, okay, we have dismissal before us. How are we going to do it? Now, the state says, I want to dismiss the case without prejudice. Defense counsel says, no, if you're going to do that, you're going to get an end run around it, dismiss it with prejudice. Sure, there was a third alternative apparently, but that doesn't mean it's an abuse of discretion that the district court should not be able to enforce its legitimate statutorily authorized ruling in a different way. It doesn't have to do it only one way.
But isn't it a different question? Ask whether the court has some obligation to think about whether there might be a way to accomplish the sanction in a less nuclear way without missing it with prejudice.
I think, again, you're conflating the sanctions. They're not the same sanction.
No, I'm talking about does the court have an obligation to consider various options?
I think when we're in the situation as a district court judge, you do what's in front of you. You don't always consider the third alternative. This was the first time I'd considered Justice Stiegel's proposal. I hadn't thought about it. The parties clearly didn't think about it below, or this, I mean, ultimately, this is the state's problem here. The state did not ask. It did not propose this alternative, and it should. The fact that this court now seems to sound like it wants to darn the state's socks and do the state's job for it. I mean, one of the big problems I have with the Court of Appeals ruling in this case also, which we haven't talked about, is that the Court of Appeals shifted the burden of everything to the defense here. It said, well, there's no proof of prejudice. Well, that's not how it works. The appellant has the burden of proving these things. If the state wanted these findings.
I'm talking about the court, whether the court has an independent obligation to consider whether there's a less ultimate sanction that would accomplish the same thing. Not defense counsel, not even the state, but the court.
I don't think the court does based on what it's in front of them. I would also point out that even if you consider this the nuclear option, it's really, if you look at those Jones factors, which we don't think really come into play because this was a statutorily authorized sanction. But if you look at those Jones factors, there are other reasons you consider. And in this case, it's clear this isn't the first time this has happened. The state's response as to why it happened was, well, we don't know. Mistakes happen, things fall through the cracks. And I understand that. But it is certainly a valid consideration of the district court not to reward negligence. And in this case, this is a residue case. This is not a person felony. This is not, no one was hurt in this. This is residue about the lowest possible harm to the state, residue of marijuana, the lowest possible harm to the state I could possibly think of. And if you are going to have a case where you dismiss it, that is the least harmful, if you're going to have this sort of balancing thought, which under the old law, there is supposed to be some balancing on who's at fault, yada, yada. But if there is any sort of balancing, this is the sort of case where you say, this is a good case. It's not going to be a major harm to everyone, that we actually can sanction the state in a manner whereby dismissal is okay. Dismissing a residue case rather than a first-degree premeditated murder case, I think we all agree the residue case is the case you want to dismiss.
Counsel, can I just, if I understand your position correctly, I just want to ask a couple follow-up questions to make sure. When you dismiss with prejudice, you have to do so to further the interest of justice. Is that correct?
Sure.
And here, what the furtherance of justice, I guess, I view it as insulating the discovery sanction. In other words, you're dismissing with prejudice, or the district court is, because you don't want the state to circumvent that discovery ruling. Would you agree with that?
I think you're also, that's part of it. The other part, again, is what I pointed out as far as stopping a repeating problem.
Okay,
And-
a deterrent then.
Yeah,
essentially.
it has both an enforcement and a deterrent effect. It's both.
And when we review that on appeal, as I understand it, your argument is that that on review, a court is not required to embrace only the least restrictive means of accomplishing the ultimate goal of furthering the interests of justice.
Correct.
It's a balancing test, in other words.
And again, we're also looking, remember, this is not a legal test here. This is an abuse of discretion standard.
Correct. Okay, thank you.
And I was informed earlier that etiquette is that I should point out that my time is run. Again, if I could say one last point, and that's to reiterate, if the state wanted findings regarding prejudice, regarding wrongdoing, these sorts of things, the place to do it was in the district court. Not now. It's not for an appellate court to make its own findings on these. There were no explicit findings. And when there's no explicit findings and when there's no request for those findings below, then this court has to presume that the district court made findings in support of its ruling. So I guess we inadvertently roundabout way covered everything unless the state brings something up, and otherwise I would at the case and wait for rebuttal.
Thank you, Mr. Dunn. Mr. Cruz?
May it please the court, Tony Cruz on behalf of the state of Kansas. As Mr. Dunn pointed out, the court did dismiss this matter with prejudice, which the record clearly shows that this was an incident that somehow the ABL lab report was not provided to defense counsel, and we found out about it. If the timeline was basically the defendant was arraigned late April. The matter was set for jury trial on June 10th. Didn't find out about the defense counsel not having the KBL lab report until the evening of June 7th, which would have been Friday.
I interrupt. I'm sorry, just for this. Can you, move the microphone? I'm not sure.
Sorry.
No, it's a problem with our microphones. We're working on that issue, but I appreciate it. Thank you.
Excuse me. So we don't find out about, or the state does not find out about that missing discovery until 5 o'clock, a little bit after 5 o'clock on Friday, with the jury trial on Monday. Once we discovered that, we provided it to defense counsel by email over the weekend. Had we been apprised of that prior to that date, we would have provided it. It wasn't a situation where we were trying to hide anything. We have an open file policy, just because there are times when reports come in. Our policy is whatever comes in goes out to defense counsel, that we don't try to hide anything. We don't try to keep anything separate. And this was just one of those situations. And oddly enough, we had 2 preliminary hearings, so I'm still not sure why that KBL report was not provided to defense counsel. But once we became aware of it, we turned it over.
I understand why you're defensive about this, but why do we have jurisdiction to even talk about it?
Because the court dismissed this with prejudice. And that to me is an extreme sanction for an oversight. Even the Court of Appeals, when I miss a deadline on a first time brief, they'll tell me, that you miss a deadline, have your brief submitted by this time period. In this particular case, once we became aware of the fact that they didn't have the lab report, this was an extreme sanction. I mean, the motion limiting.
You agree we don't have jurisdiction to consider the court's ruling on excluding the lab report from evidence?
I would agree with that, because the only issue that the Court of Appeals took up was the dismissal with prejudice. So I think
that's all you appeal. That's in your
Right.
notice of appeal and
Right.
in your docket statement. So
Right.
it wasn't even that the Court of Appeals limited you. You picked your fight. And so that's what you've got. And so you're saying that missing with prejudice, the court didn't consider the inadvertence of the state in creating this problem.
correct. And it goes beyond just, and I hear it all the time because I'm the main drug prosecutor for Erie County. Well, it's only a marijuana case. It's only this case. But the problem is, if this court allows this type of sanction for this type of violation, that opens up the Pandora's box for every other.
But how is
case.
it fair to the defendant? You know, as I remember, the defendant was from Topeka. The Topeka comes to Geary County, ready for trial. It's the morning of trial. The defendant's there, ready to go. And now you're showing up wanting to dismiss the case so that you can refile and correct your problem. How's that fair to the defendant?
Had we known about the lab report not being turned over, we would have turned it over sooner. So defense counsel knew that we didn't have it in our file because they even looked at it.
So
And didn't notify
the
us.
court needs to be unfair to somebody, and you're choosing to say the court abused its discretion by being unfair to you rather than unfair to the defendant.
I don't see it being unfair to the defendant because again, there's an old adage, I believe it's out of his court, that a defendant is entitled to a fair trial, not a perfect one. And I think in this case, again, had the state been apprised of this issue prior to the Friday evening beforehand, we would have turned it over. And even over the weekend that we turned it
The
over.
Court of Appeals, Mr. Dunn is saying the Court of Appeals did, which is to put that burden on Mr. Molyneux. Didn't you have an obligation to be sure that this defendant was given the report?
We do the best that we can, but again, sometimes things, and again, had it been in our file,
What does the discovery statute mean? When the defendant had filed a request for all discovery, does that mean the state does the best it can? Or does it mean it provides all of the evidence that would fall under the discovery provision?
we provide all of the discovery as it comes in. And the discovery statute specifically even has a section that says that we have a continuing obligation to provide discovery. And again, if this was things happen, I don't take,
I don't think anybody's saying the state was
but again,
fictive or malicious, or there was a bad faith involved here.
right. And again, had there been bad faith, had the defense filed a motion to compel, saying, look, we asked for it, we still don't have it, what's going on? And we refused to turn it over or didn't turn it over in a timely fashion, then I would agree. Dismissing this with prejudice would have been the proper sanction. But being advised that they don't have something the eve of trial and then providing it and then still being sanctioned and then being given the most extreme sanction, and that is having it dismissed with prejudice, that doesn't even give
Bruce,
the
let me
opportunity to cure it.
interrupt you very quickly. You keep referring to the dismissal as a sanction, but it's my understanding, and I think Mr. Dunn talked about this, that there's two, or even Justice Biles, there's two buckets here. There's the bucket of excluding the lab report, and that was the sanction, right? Excluding the lab report. And at that point, the trial would have gone on. But you, the state, filed a motion to dismiss at that point, right?
I mean, an oral motion.
Right, a motion to dismiss. And then defendant comes back and says, a motion to dismiss without prejudice so you can refile. And then defendant comes back and says, whoa, if you're going to, we oppose that motion to dismiss. But if you're going to grant it, you should grant it with prejudice, right?
Right.
So that's not really a sanction. That was a ruling based on, it didn't really have anything to do with, I mean, you could say it's related, but did it have anything to do with the issue that has not been appealed in an interlocutory appeal, which could have been done, correct?
That I'm not aware of. I'm not really sure
Okay.
that the state could have appealed a motion in limine.
Like a suppression motion, right?
Correct.
So the state had a lot of different avenues it could have pursued, but the avenue it decided to pursue was, we want to dismiss this case and refile it. So what the district court had in front of it was dismiss as the state requests without prejudice, or and on the other hand, dismiss with prejudice. And then would you agree that we look at the court's decision based on that for an abuse of discretion?
Use of discretion based on and those, the two sanctions, and I call them two sanctions because that's what I believe they are. And I apologize, my pen blew up this morning, so I've got blue all over my hands. The court, in the state's opinion, the court basically had issued two sanctions. One was the motion in limine. The other one was the dismissal with prejudice, because if you look at the record.
How can that be a sanction when you are the one that requested?
Because I requested it to be dismissed without prejudice. The court dismissed it with prejudice. The state's concern is there was no legal basis to dismiss it with prejudice. Because when they filed the motion the motion in limine, the court had the various options. The court could have continued the matter. The court could have.
But that wasn't what was before the court. You moved to dismiss. So you're saying the court, even though it's presented with a motion and a response, then the court is required and has the burden to say, well, what else can I do that they're not asking for?
I think the court has the inherent power, and I think that they have the
power, but do they have the duty?
I do.
When we're looking at abuse of discretion.
I think that they do, because the cases I cited, there were discovery sanctions where defense or the court said, okay, fine, we'll not get into that topic till tomorrow.
But aren't you conflating the sanctions, for the discovery violation? Here, the motion, it seems to me, when when we're looking at abuse of discretion, I mean, I don't really see where the error of law is, because the court is saying, am I going to allow the state to refile this whole thing? So just like none of this happened. I mean, it's really abusive process, right? So, I mean, you could say the district court did it to avoid abusive process.
I don't see where it's an abusive process if, and I know that there was, the defense counsel said that the state could have still proceeded to trial.
Right.
Not on a residue case. Because again, normally, and I understand that cases can be tried on circumstantial evidence, but you've got, in those types of cases, you've got the ability to have other types of evidence. For example, homicides, you have a dead body. The question is not whether or not somebody was dead or not. In this particular case, you have residue. The officers can't testify that there was marijuana residue in the pipe, because all they can say is the pipe smelled like marijuana.
Right.
So again, to prove it to a jury
What's wrong
beyond
with
a
that?
reasonable doubt, I'm sorry, I don't know if any prosecutor that's ever tried a residue case based on circumstantial evidence where you don't have the lab report.
Mr. Cruz, also one other question. Do you think when we're, because you didn't ask for more particularized findings when the district court did this, is it possible for us to take into account that this was a pretty serious case? Because even though it's a misdemeanor, this is a very low misdemeanor residue. This was his third hit, right? So turned it into a felony, correct?
This was a felony, yes.
Right. And so what would the jail time be on that?
That would depend on his criminal history, but
Prison.
If he's got no criminal history, you're talking 10 months. If he's an A felon, you're talking 42 months.
Right. So this isn't some diversion case or some probation case. This is a felony. And actually, when the state filed its first information, it said there were 2 prior convictions for possession. So it's a felony charge on the residue. They had the first preliminary hearing, and then the defendant filed a motion to dismiss for lack of probable cause, because again, the state inadvertently, I don't believe there was any malice, but the state inadvertently did not have a journal entry on one of the priors. So that was dismissed. And then there had to be another arraignment, a second information, a second preliminary hearing. Do you think that the judge took that into account, that this was the second mistake that the state had made to cause a lot more? I mean, this is a lot of extra hearings and paperwork and, and this is what turned it in. This was a felony.
Yeah. To back up just a bit, just because it's a felony possession of marijuana doesn't make it presumptive prison. This was a presumptive probation case.
Okay.
Okay. As far as the first preliminary hearing, we had documents. Unfortunately, the documents that we had requested didn't have everything that the court
Didn't have the
wanted.
journal entry.
No, we had journal entries. Just, it was a matter of, if I can recall correctly.
Well, you agree. We don't need to go into the
Yeah.
specifics, but you do agree that it was an inadvertent mistake on behalf of this the state that happened in July of, well, I guess it happened in January of 2019, which pushed everything back a couple months, right?
Right, but we did provide the journal entries, except when, and it got bound over.
Right, because you refiled.
Right, and
So
then.
so you already refiled once.
Well, I didn't refile, I filed amended complaints, so there wasn't anything that was pre-filed. But the district court did not agree with the magistrate court to find there was probable cause, alleging that the journal entries that we had provided were insufficient to prove that he had two priors. And that's.
I
what
show
we
the
had to do.
motion to dismiss count one was granted on March 18th, 2019. So if it was dismissed, you couldn't have filed an amendment. You had to.
That the felony charge, because we hadn't proven that. It was a felony.
Exactly. Right. So I think we agree on that. Thank you.
Getting back to Justice Stiegel's question, because this was a residue case and you needed that lab report in order to make your case, had the court simply said your motion to dismiss without prejudice was denied, it has the same impact on the state as the court's ruling, which was dismissal with prejudice, right?
I'm sorry.
You weren't going to be able to go to trial and get a conviction
No,
with,
no.
based on the discovery sanction. So regardless of whether the court had said, just denied your motion, not said anything else, just no, you were in the same place, because the charge was going to be dismissed with prejudice, or there'd been acquittal, right? You didn't have a case without that lab report.
Right.
Okay.
One quick clarifying question. At the beginning of your argument, you were talking about the timeline with regard to the turning over of the report.
Mhm.
It sounded to me like you were suggesting that perhaps the defense was essentially playing possum. Is that right? In other words, I wanted to clarify, did I hear you correctly that from the state's perspective, the defense knew that it didn't have the report and it waited up until eve of trial to notify the state?
That's what it seemed like.
How much time passed between the file inspection and the notification?
The final, okay, the arraignment was in late April. The jury trial was June 10th. They inspected it June 6th, which would have been a Thursday. And then they didn't file the motion in limine until Friday. And I want to say it was after 5 o'clock, but if it wasn't after 5, it was like right at 5 o'clock.
So 24 hours later.
Yes, ma'am. And unfortunately, because of the weekend, had no real way to contact the court to see if we had, on the second preliminary hearing, had not that we drawn the exhibit or accidentally
So
sent it to
just,
somebody else.
I guess, final question, that short period of time doesn't strike me as playing possum, as I put it. Would you agree with that?
I would say that to wait until, had defense counsel notified us that day, hey, where's the lab report? We would have tracked it down that day and provided that day, because I was able to do that over the weekend. And I understand that it was a short setting, because generally we don't have jury trials where you have an arraignment in late April and then a jury trial in June. Normally.
Wouldn't the
they go out
defense have
October 9th.
filed their same motion? I mean, I just don't see how that would come out any different. Whether it happened on Thursday or Friday, or what, I don't see the difference.
Had it been known on Thursday, we would have, again, been able to do some research about why it hadn't been turned over. But again, to wait until Friday afternoon, that gave us like no time, so.
Thank you,
Thank you.
Mr. Cruz. Ben, you reserve 2 minutes.
As I always say, this is at my own peril. The only thing I really want to mention again is that if the state contends this is some sort of possum situation, they could have gotten that finding below. That's the place to have it. That seems like a factual finding to me. Again, this is not a Pandora's box situation where if you do it in a residue case, it can happen in any other case, because this is an abuse of discretion, and the courts have said we decide these things on a case-by-case basis. Case-by-case means it doesn't control every single case. You look at all the different factors that came into play.
Counsel, looking at our decision in State v. Bolin, it suggests to me that a district court does not have the legal authority to dismiss with prejudice unless there's actual prejudice to the defendant. Would you agree with that?
There's an implication of that. It's also on a case by case there, because
guess
you can
my-
have, if say the prosecutor is thumbing his nose at the state, which I think is the Clovis case, then that outweighs the prejudice in and of itself. We contend, we pointed out some prejudice.
Well,
Counsel below said this is the most important piece of evidence. This is a residue case.
Right.
I gave you some reasons, but the bottom line is we have to presume, that's the law. If there's no objection or a clarification of findings, we presume the district court made that finding.
I guess I just want to cut to the chase and say, why isn't this a case where the state wins the battle, but you're going to win the war? I mean, there is no prejudice, right? Because this case was not going to go forward. The state was not going to get a conviction. period.
I don't know what would have happened. That's why things go to
Isn't
trial.
that
That's
the-
why people settle in civil cases.
I understand, but
You never know what's going to
what
happen.
I'm trying to
Any number of
think
factors.
about
come into
is
play.
what would the right way to have approached this been? And if it's true that our case law says, look, there has to be actual prejudice to the defendant. And this seemed like a quick trigger on dismiss with prejudice. Why doesn't the state, as I put it earlier, win the battle but lose the war here?
Again, I'm not seeing it as a quick trigger because again, this was, the state below said, oh, this defense counsel always comes in and asks for dismissal. But that's not what happened here. That isn't what happened.
But you
Defense
agree-
counsel went the lower sanction exclusion. The state asked for
Right,
dismissal.
But you agree.
And it's a case of be careful what you wish for.
You agree that the district court has to have a legal basis to enter an order dismissing with prejudice. Can't
Yeah.
just do it because they woke up in a bad mood.
Sure.
and want to go to
I
trial.
completely agree there, and they have a
That
totally
the-
legitimate
The
reason
legal
and that
ba-
we're
the
enforcing
legal
our earlier
basis
rule.
here is to enforce my discovery sanction.
Correct.
That's the legal basis.
Yes.
And we have case law that says what you have to do when that's the case.
So
And you would agree then that we're just at just an old fashioned abuse of discretion
That's-
review of that.
yeah, and in my line of work, normally I don't advocate for the abuse of discretion standard, but this is one of those situations where perhaps it works in my favor.
Are you conceding that there isn't prejudice from the standpoint of the defendant having to pack up and
Oh, we absolutely believe you're correct. there.
come in from Topeka to Geary County and, take a day off of work or whatever, especially after the other delay in proceedings and other things that happen going forward? It seems like to say there's no prejudice ignores certain realities.
I don't see how we can say there's no prejudice. Again, this is a simple residue case. This is 299 days, I believe, if I counted correctly, after arrest here. There's no reason a simple residue case cannot be tried within 299, no motion to suppress, nothing. The only motions arose in the last month based upon what happened. We had a motion in limine on prior convictions. That's a pretty standard thing. We don't want you to bring in 6455 stuff. It's the only motion in this case until the discovery issue, which was the second motion. There's two motions, simple case. No reason this should have been continued. And sure, I don't see how that's not prejudicial to keep saying, you're going to have to come back for something that wasn't your fault at all, something you didn't ask for. Sure, I think there's other forms of prejudice. And then again, I'd fall back on the final thing. If the state wanted findings regarding prejudice, they should have asked for them at the trial court level. Thank you. And we'd ask this court to reverse the Court of Appeals and affirm the district court.
Thank you to both counsel for your arguments this morning. The court will now take this matter under advisement. Mr. Shima, would you please call the second case on the morning docket?
Second case on the docket for Tuesday, March 29th, 2022 is appeal number 122039, State of Kansas versus Johnny C. White, Sedgwick County, briefs both sides.
Counsel, will you please come to the lectern and enter your appearances?
May it please the court, the appellant Johnny White appears through Casper Shire, Kansas Appellate Defender Office. And Your Honor, could I please reserve 3 minutes for rebuttal?
Brandon.
Thank you, Your Honor.
May it please the court, Assistant District Attorney Julie Kuhn on behalf of the state, present and ready for argument.
Shire.
Thank you, Your Honor. Again, Casper Shire appearing for Johnny White, and may it please this court. In 2017, Johnny White was accused of a sex offense dating back to 2009. When he spoke with law enforcement about those accusations, he denied them and he agreed to take a polygraph exam. No report of that polygraph exam was ever produced, but Johnny's interrogators told him that he had bombed the test, that he was lying, and that he needed to confess to give his accuser closure. After about 2 hours and 45 minutes of interrogation, Johnny told a detective that his accuser was not lying, and Johnny's confession featured prominently at his trial. But the jury never heard about the polygraph exam because the district court, at the state's request and over defense objection, excluded any and all reference to the fact that the confession had come on the heels of a polygraph. Johnny also objected to the state's use of a tearful confession to a separate crime and to the state amending its complaint on the 4th day of trial to expand the charge date range in this case by nearly a year. Johnny ultimately chose not to testify in this case based on the limitations on his intended testimony from the polygraph order. Johnny was acquitted on 1 count of aggravated indecent liberties with a child, but convicted on a 2nd count. And my plan here today is to start with the polygraph issue and to focus on that issue. I'm certainly prepared to talk about the other issues and to take questions on those issues, but if I don't get to them, I will submit those issues on the briefing.
Let me start by asking you on the polygraph issue. In both your brief to the Court of Appeals and to us, you say that the officers tricked your client in regards to the polygraph results. I don't see any evidence that the investigators falsified what the results would be, or that we even know what the results of the polygraph were. What's the basis for your saying that they tricked it?
This court has said that the polygraph is an inherently unreliable test. To tell somebody that they failed a polygraph is kind of an oxymoron. You cannot fail an unreliable test. So going into an interrogation and telling somebody you bombed that polygraph, we know you're lying, you might as well confess, is coercion.
So were you expecting the jury to take some sort of common knowledge about the inherent unreliability of polygraphs in order to make this argument that by telling him he bombed, that he was being coerced?
Well, Your Honor, I think once the polygraph evidence comes in, it comes with a limiting instruction, and that's what defense counsel was asking for below. A limiting instruction that tells the jury, you can consider this evidence to determine the credibility of Johnny's confession, but polygraph evidence is not used for the purpose of determining whether Johnny was speaking truthfully or untruthfully when he submitted to this test.
You didn't make a proffer that you had an expert to say anything about polygraph, right?
No.
And so the second you start fighting about the results of this test, it seems natural that the state's going to need to come in and go, you know, really, what was it? Atterbury was the polygraph examiner. He's really, really good at this, and he knows. And these results, he was telling the truth. Seems extraordinarily prejudicial to the defendant to be wading into that area, and I don't see how a limiting instruction takes away from that prejudice.
Well, respectfully, Your Honor, I don't think evidence that the polygraph administrator, I'm sure he would take the stand and say, I've been doing this a long time. I know what I'm doing. I trust polygraphs. I think they're great. But the fact is, this court's case law says otherwise. The fact is, this court's case law says the polygraphs are not trustworthy. And so I just don't see any reason to dive down that rabbit hole. I don't see any reason to relitigate the veracity of polygraph tests when this court has said that they are not reliable.
That's
Counsel,
why we exclude reference to polygraphs. I mean, the district court was following our case law, wasn't it?
I think the district court overread the case law, Your Honor. Yes, the district court was relying on this court's
What
case law.
evidence was it that the defendant wanted to put in front of the jury?
Johnny testified at the pretrial hearing on the motion to suppress that also doubled as a motion in limine trying to keep the polygraph evidence out. And he said that he didn't understand polygraph evidence. He said that he felt pressured to confess by the polygraph, by the officer's use of the polygraph to tell him that he was lying.
But how is it? The confession is not challenged here. I mean, a minute ago you said it was coercive, but that's not actually a correct statement of the law, is it? Law enforcement officers are permitted. I mean, they can tell a suspect that, his buddy gave him up when that's completely untrue. There's nothing, our case law says that's not outside the bounds of what law enforcement can do.
And as much as I don't like that case law, I have to agree that's right, Your Honor. But what happened here, and the district court did do the voluntariness analysis. We had a Jackson v. Deno. The court determined that this was voluntary. And that's the court's job, to determine whether this confession gets to the jury at all. Then we have a separate question that's for the jury and not for the judge, which is, do you believe this? Do you believe that this confession is accurate? And that question needs to go to the jury, even though the court has found the confession is voluntary. And it's the same.
How does the exist? That's I appreciate that answer, because that gets to me, the part of this case that I can't quite make the leap, which is how is the fact that law enforcement said you failed the polygraph test, how is that relevant to the credibility of the confession?
Because Johnny wanted to get on the stand, as he did at the pretrial hearing, and say, this is what Crane v. Kentucky talks about. When a confession is in play, when the accused is trying to deal with a false confession at trial, they have to be able to explain to the jury why they said they didn't, when they really did not. And here, the reason is that investigators told Johnny he bombed a polygraph, that Johnny didn't understand how polygraphs work, that Johnny thought he was cooked, and that Johnny confessed to give his, in part because they were, hitting him up not only with the fact that he bombed this polygraph, but also that there was a girl out there that needed closure. And that's, based on his history, that's an issue that Johnny would have been very sensitive to. And that is why he confessed to these offenses. And he needed to be able to tell the jury, this is why I confessed. Because he couldn't do that, he had very little chance of succeeding at trial.
And when you do that, if that testimony comes into evidence, I want to go back to, I think, Justice Biles's point. What does that open up then for the state to introduce? Doesn't that then allow the state to, for example, produce testimony relevant to the reliability of that examination and other circumstances that would suggest that the polygraph was administered in accord with prevailing standards in the industry?
I think it certainly opens the door, Your Honor, to evidence that, at least in the opinion of this evaluator, Johnny failed the polygraph. Otherwise, this evidence makes no sense. Even from Johnny's standpoint, it doesn't make any sense to go in and say, I went in, I took a polygraph, I passed it, but I confessed anyway. And that's certainly not what he was trying to put on. But as I said before, Blosser and Mason and the line of cases that follow it say that the veracity of polygraph results are settled law. We do not need to relitigate that in every case. I think the best approach is, once those results come in, to give the jury a limiting instruction and tell them, you can use this to determine whether or not the confession is credible. You do not use it to determine whether or not Johnny was speaking truthfully or untruthfully.
So why wouldn't that limiting instruction be relevant, or the state be able to use that type of limiting instruction when it wants to offer polygraph results? I don't understand how just having it in this instance, I don't want to use limit twice, but limits the state from introducing polygraph evidence in other types of cases. And hey, just give this limiting instruction and that'll cure it. Is that a problem?
I don't think it is, Your Honor. And I cited to a number of federal cases in my supplemental brief where they really struggled with this issue. And a lot of the federal cases dealt with, a polygraph confession comes in, the accused wants to and does take the stand and say, yeah, but I was in there for 3 hours and they told me I was lying over and over again, and that's why I confessed. Well, that opened the door for the state to bring in the polygraph results. The reason they told you were lying is because you failed a polygraph, right? Well, yeah, that's where we ended up. So there is some door opening going on here. And here it's the state that opened the first door. The state opened the door for Johnny to bring in polygraph results here. And they did that by relying on a polygraph coerced confession. They did not have to do that. They had the accuser's testimony. They had additional evidence that they felt suggested that Johnny had committed these offenses, and they could have tried this case based on that evidence. They chose to bring on the polygraph coerced confession, and they created a lot of evidentiary headaches for the district court.
One of those headaches is the limiting instruction that at least was proposed. And I want to go back briefly to that because I'm not sure I even understand the limiting instruction. It seems to me that it, as you just recited it, it is that the evidence can be used to determine the credibility of the confession, but it can't be used to determine whether he's telling the truth. And aren't those the same thing? Isn't credibility the same thing as whether or not he's telling the truth?
But it's the difference between the credibility of the confession. Do you believe this confession, or do you think it's something that officers pried out of him?
Well, whether they pried it out of him has nothing to do with whether it's true or not, does it?
But it does have to do with whether or not you believe it.
Help me understand that.
Let's say that I confess to a crime that I didn't commit. All of the evidence at trial is completely inconsistent. with my confession. Now, the jury has every right to say, well, I looked at him, I heard that confession, but I saw all of the other evidence as well, and I just don't believe it to be true. So I'm going to return a verdict of not guilty. That's the extreme case, but this is essentially the same thing. The jury is going to hear the confession. The question is, do they believe it? And the jury needed to see all of the evidence that was out there. The jury needed to see how the sausage got made in this case. The jury needed to see what officers did to Johnny to get those words to come out of Johnny's mouth. And because they didn't, Johnny was denied the right to present a complete defense by presenting to the jury all of the circumstances that led up to his confession. Thank you, Your Honor.
May it please the court, Assistant District Attorney Julie Kuhn on behalf of the state. It is our position that the court properly exercised discretion in excluding the evidence of the polygraph exam. The court standard to review this decision is to admit, the decision to admit or exclude evidence is reviewed for an abuse of discretion, as this court knows. Additionally, the court exercises unlimited review over whether the district court's decision to exclude evidence infringed upon a defendant's constitutional right to present his or her theory of defense. We agree with the Court of Appeals determination in this case that the exclusion of the polygraph evidence did not violate Mr. White's right to present a defense. A defendant has the right to present his theory of defense, but that right is not unlimited. It's subject to reasonable restrictions. There are policy reasons that this court is well aware that exist to protect the defendant. And that is why the polygraph evidence doesn't come in. Because
Let me ask you a question.
yes,
So the defendant relies primarily on the United States Supreme Court case of Crane versus Kentucky.
mhm.
And we even just recently cited the holding in that case in the Khalil Asalami in 2021. So in that case, they found that the trial court's exclusion of evidence surrounding defendant's confession violated his right to present a defense. And also in this case, there was a Jackson v. Deno hearing, and they already determined it was voluntary. So the Supreme Court here is making a big difference between the voluntary and the credibility. And in that case, the defendant was 16 years old, and he was not permitted to testify about his detention in a windowless room for a protracted period of time, being surrounded by as many as 6 police officers during interrogation, repeated denials to telephone his mother, and being badgered. And the court held it would be procedurally unfair if the state were permitted to exclude competent, reliable evidence bearing on the credibility of a confession when such evidence is central to the defendant's claim of innocence. How do you distinguish this case from Crane?
Well, here we don't have a 16-year-old. We have an older gentleman, if I recall. I don't recall his age. I have
Basically, how do you distinguish it based on the law, not on facts?
Well, first of all, the polygraph evidence, these protections have been put in place to protect a defendant from the unreliability thought to go with polygraph, and to the fact that juries, if this evidence goes to a jury, it takes them out of the truth finder because they would put too much weight on the results.
What if the results were never given to them? I don't think the defendant is asking for the results to be published. What they're doing is saying, look, these are the circumstances surrounding our guy's confession. And the question is that confession, did he confess because he felt pressure and he lied, or was his confession credible?
And to that, you cannot divorce, getting to that, the circumstances from the results of the polygraph.
Why not?
Because in this case, defendant argues that he wanted to talk about the detectives telling them he was lying, which also brings up El Nicky. That wouldn't have come in anyway, because we cannot put on, that's an improper comment on defendant's credibility. We know that. We couldn't have put that on. Additionally, he wants to talk about telling him he bombed the test. Well, both of those things necessarily deal with the results of the test.
Do they though? I mean, I guess I'm piggybacking on Justice Standridge's question. Is this really polygraph evidence? Or is it evidence about what the defendant was told in the context of the confession? And I want to ask a hypothetical to get to my point. What if law enforcement had faked it? They put Scotch tape on his head with wires, right? And they're like, it's totally fake. Could the defendant say, well, this is what they did to me, and I thought they had, basically say what the defendant is saying they want to say, give the context of the confession. And in that hypothetical, there never actually was a polygraph exam administered.
That hypothetical actually gets me to another portion of my argument. Defendant wants you to do something here with the limited purpose exception that we can already do. All he had to do is.
If you could, I don't want to stop you from going where you want to go, but I kind of want an answer to the question also. Like, why wouldn't the defendant be able to talk about that if that had happened? It's not really, we're not talking about polygraph evidence. We're talking about what the defendant was told by law enforcement, which is different, isn't it?
If there indeed was no polygraph, and at the same time, investigators, we have case law that says that they can use tactics or interview tactics to interview a defendant that don't have to be truthful. I believe that could possibly come in. But I still feel that that is different than the policy reasons we have behind actual polygraph evidence that are in place to protect a defendant. At the same time,
I guess
where
I'm sorry to cut you off, but again, to cut to the chase, I guess what I'm asking is, why couldn't the defendant be permitted to testify as to the circumstances surrounding the confession and just leave it at that? Why isn't that the right way forward? I mean, I'll say I don't know how it helps the defendant that much, but why shouldn't the defendant be allowed to do that?
And I think he could have been allowed to do that if he stipulated to and waived his right. These protections are in place for him.
No, I'm not talking about bringing anything about the polygraph in. About the examiner doesn't, none of that comes in, because that's our case law. That's not admissible. I'm just asking what's wrong with letting the defendant testify. They told me I failed a polygraph exam.
Because our case law from this court has said that no evidence regarding the giving, the taking, the results are to come in.
That's
now.
Okay.
So why does the state then utilize this test or even allow it to happen at all? If it's inherently unreliable, can't be admissible, what's the point of utilizing this as an investigative technique?
I believe simply that it is used as an investigative technique.
Well,
but it was not, and the evidence or the record shows that I believe this was brought up at a first interview and he agreed to do it. And then a couple of weeks later is when they went, gave him all of the required warnings, and he still agreed to do it. And the district court, as we've heard, they found that there was a hearing, a motion to suppress Jackson v. Deno, that this was voluntary, and there was no coercion involved. So I cannot speak to the broad question of why does law enforcement still use this, but I believe it is a tool that they have in their investigative toolbox that they can use.
Was it similar then to if you have co-defendants and you've got the co-defendant in the interview room next door and say, oh, your co-defendant has spilled the beans on everything. We've implicated, and in fact, we bought him McDonald's to thank him. And then they walk him by the interview room. He can see that the guy has McDonald's. And so then he goes, okay, I'm going to go confess. Would that information be able to come in? Because it sounds like what you're saying is the state uses this as a tool. Oh, you flunked, they could have just as easily told him that he flunked the polygraph test when he didn't. They're allowed to do that too. They're allowed to do anything. So why doesn't the context of this come in to use, the constitutional right to present a defense without the, whether a polygraph test is scientifically reliable is a whole separate issue.
Again, it could have come in. All this defendant had to do was stipulate, I want this in because I will, and he had to do it at the district court.
But he didn't
had
want
to
the results
expressly
in.
in front, but that's the strange thing. I don't know how you divorce the circumstances from the results.
What if the
because-
police lied and said you flunked even though he didn't?
But we don't have that here.
Right, but isn't that the whole point?
I don't think that's the point here.
Well, we don't even know in the record we don't know whether that's true or not here,
Whether what's true.
whether he didn't pass or not. It's not in the record.
We have a full hearing on the motion in lemony, and I believe we have testimony that from, again, I didn't start with this case, so if the record would bear it out, but I believe we have information from at least Detective Ribble, that he had failed the polygraph. And that's what Atterbury had communicated to him. I don't think we have anything in the record that indicates that these were detectives that were lying to Mr. White to
I wasn't
coerce
saying
him.
that. I was just more pointing out that, what we rule in this case could apply to all cases.
And I understand that. But again, I don't think we need a new way to do things when in this case, if defendant wanted this, he could have stipulated at the district court, he could have made a very specific
Stipulated to what?
to a waiver of the protections that we have for him. He could have stipulated to have this evidence come in.
Okay, so he has two
or waive the
choices.
protections.
The evidence comes in that shows that he did not pass, or he could not do anything. But what the defendant seems to be asking for is somewhere in the middle, which to me, I'm really having trouble distinguishing Crane versus Kentucky on this one. But somewhere in the middle of, I don't want the results to come in. I just want you to know that, I was in a windowless room for a protracted period of time, surrounded by 6 police, just the context of when he made his confession, so that a jury, when he presents it to a jury, they can decide, you know what, he probably lied when he made that confession.
But we also have a difference here in that when he confessed to one of the counts and he denied the other, and we have a jury who acquitted him on the count that he denied. So the jury believed his denial and believed the count that he confessed to. This isn't a situation where it was he confessed to everything. He also didn't confess immediately. These officers didn't come in and say, you failed, you bombed. There were 20 to 30 minutes between the conclusion of that polygraph and when the detectives were in there speaking with him, when he finally said, she's telling the truth, she's not lying.
But at the end of the day, isn't the defense asking under the limited use exception to put in front of the jury the fact that he did fail a polygraph exam, right? Isn't that real? Otherwise, how is the defendant explaining sort of the incongruity between the trial defense and what happened during the interrogation? And right, doesn't defense have to get the results in to explain away the confession? I mean,
I would agree that yes, you can't have just part of it to support his defense that the confession was coerced. I think you would necessarily have to have the results as well, because
not
otherwise
coerced, I'm sorry, but unreliable.
unreliable.
Yeah.
Sorry. I think you would necessarily have to have the results, because otherwise it doesn't make sense.
Well, why?
So
Why do you have, again, I guess this is where I don't understand this case. But the defense argument is it's all about his state of mind. Whether he passed or failed is completely irrelevant. The only thing, as I understand it, the defendant is saying is, I wanted the jury to know that my state of mind was, I believed I had failed a polygraph test. And that's different. That's different from whether he actually, quote unquote, failed or didn't fail. It's really all about his state of mind.
it is, but it's our position that it still gets into the results. And up until today, I believe the way I understood the argument was that they only wanted the circumstances. They did not want the results. They wanted to divorce these two from each other, and only deal with these circumstances.
Let me just one more question. Why is the state so, you may not be able to answer this either, but why would the state be so upset if the defendant wants to tell the jury, they told me I failed a polygraph test? Like, to me, that benefits the state. I just don't understand why the state would be so adamant that that can't happen.
Well, it could, but we have rules that we have to follow, and these are put in place to protect the defendant. So as I argued, he could have waived these protections.
No, you're trying to get the results in.
And that goes back to, I don't think you can divorce the circumstances from the results in relation to this polygraph evidence. And that would be our position. If he wanted this to come in, he could have made a very explicit waiver, a proffer in the district court. There is no proffer as to how this was used. We only have an argument on appeal now of how this was going to be used. There was no proffer before the district court. So it is our position that his right to present a defense was not unlimited. And I think we can, if this court goes to the harmless analysis, if they determine that this was error, I think we can look to the fact that it's very important to look to the fact that he was acquitted on count 2, and the jury believed his denial, necessarily believing his confession. Additionally, the district court in that Jackson v. Deno hearing reviewed the length of the interview, the accusations of lying, and all other circumstances, and found that the circumstances surrounding this confession were not coercive.
Before you sit down,
Hmm?
could you get to the last issue that I think, at least how I have the last issue, and that is the evidence that was produced on the videotape confession from the prior trial.
Mhm.
The Court of Appeals found that was error to allow that, and then said it was harmless. First, you had a stipulation that there was the prior conviction. What was the point of then producing the videotaped confession? You already had the evidence that there was a conviction.
Well, I can't exactly speak to what the thoughts were at the time of trial. Backing up to the Court of Appeals decision, what I would note is that the Court of Appeals noted that it does not reweigh evidence and then assumed without finding that there was error. I will acknowledge we did not petition that. But it's not necessarily our position there was error, but I'll roll with.
Well, you're going to want to roll with it, but how is
Yes.
it, how is it not, how is it harmless? I mean,
How
this
is it harmless?
Dramatic testimony
I
and
understand.
powerful testimony on it now that that was admitted testimony that was error.
Well, it's not a situation that there was no evidence ever going to come in. This is a sex case with 6455D propensity
And had a
evidence.
stipulation to the conviction.
And
so-
that stipulation came late in trial. And again, this is not a situation where no evidence would come in. It would have been the stipulation plus detective's testimony. There were three ways to get this evidence in. A stipulation plus the detective's testimony, the video, or having that victim come in and testify to what happened. And I believe the prosecutor at the time determined that this was the middle ground between the three options that she had. Additionally, if you remove this video confession and replace it with a stipulation and detective's testimony, it's our position there'd be no difference in the outcome. The jury would have still weighed the evidence regarding the details of the current victim's allegation, the fact that defendant admitted to touching her, and then the fact that he had a prior conviction for the same offense with which he was currently charged.
Can I ask quickly on that videotape, was there evidence that a jury could have taken from the video confession that established a course of conduct or similarities, parallels between the prior convictions and the course of conduct under the most recently charged offenses that would not have been available through the stipulation?
I believe that's possible. I honestly have not, because I came into this late, seen the video. But I believe that was an argument at some point, is that some similarities between the first victim and the second victim. So ultimately, it is our argument that there's no reasonable probability that the 2014 videotape evidence contributed to the verdict in an unfair manner, demanding reversal of Mr. White's conviction in this case, particularly given the fact that the jury opted to acquit him of the second charge that he was facing. If there are no other questions, we would ask this court to affirm the Court of Appeals and the District Court.
Questions? Thank you, Ms. Coon.
Thank you.
Prior, you reserve 3 minutes.
Thank you, Your Honor. And I'd like to respond to some of the state's harmlessness arguments. First, as to the polygraph issue. I think the biggest thing here is that there is a direct line between what Johnny was polygraphed on, what Johnny confessed to, and what Johnny was convicted of. There were 2 accusations here, both stemming from the same event. But the first was that Johnny touched his accuser. The second was that Johnny made his accuser touch her. He was polygraphed only on the first accusation, that he had touched his accuser, not on the accusation that he had made her touch him. That is exactly what Johnny confessed to. He did not confess to a count that he did not fail the polygraph on. Also, that is exactly what the jury convicted him of. They convicted him only of the count that he was polygraphed on, and only of the count that he actually confessed to, based on that polygraph. So it is very clear that this confession played a key role in the way these verdicts came down. On top of that, the state actually got up in closing argument and said that this was not an emotional beatdown. Johnny could not meet that argument. Johnny could not meet that argument because the state took active measures to prevent him from putting on the evidence that he needed to put on to meet the argument, to say that this was an emotional beatdown. They gave me an inherently unreliable test, told me I failed that, leveraged that into sympathy for this poor girl, and got me to confess. So absent the error in not allowing Johnny to present evidence bearing on the credibility of his confession, there is every reason in the world to believe that this case would have come out differently, and the state cannot prove otherwise.
I feel like we're, all right, I guess I feel like I'm shadowboxing in this case a little bit because we don't exactly know. This is extremely fact specific. We don't have Justice Stiegel's hypothetical where the investigators faked a polygraph. Or just said you flunked a polygraph and the guy never took anything. I mean, you know. So it seems like you want to take this very highly radioactive, prejudicial evidence. And that's why it doesn't come in, because juries think that you hook up scientific things and it's got more credibility and you've got these professional officers. But walk me through, it feels like you want to just say a little tiny bit and then keep the state from saying anything in, you know, to bolster or flesh out the details of this polygraph. For example, Mr. White would go in and testify, they told me I flunked the polygraph. And you want to give this limiting instruction that somehow the jury's supposed to block out that a polygraph really occurred and that he really flunked it. It seems like in response to that, the state would be able to get in to the notion of why would you think that statement had any force and effect on you? In other words, did you really sit down and take what looked like a polygraph? What did the investigators do? What did they strap on you? It wasn't Scotch tape, it was real equipment. And who sat across there? Well, you know, it was Agent Atterbury. It seems like they build out this whole notion of the validity of this test just to lay out what really happened to this guy before he confessed. That just seems highly prejudicial. I can think that if the role was reversed and the trial court had allowed your client, allowed defense counsel, the trial counsel, to have done this to your client, we'd be on a 1507 in a minute on an ineffective assistance of counsel. It's just, I don't see how you keep this, you know, this is a Pandora's box, and I don't see how you keep Pandora in the box. And it almost seems like you're saying, all he wants this much, and they don't get to say anything. And I don't think that's the way this gets to play out. The state has got to be able to probe why this guy would believe what these officers were telling him. And that's the danger here. And I don't see how limiting instruction prevents that prejudice. So that's my, you know, that's a long response to what you've been arguing about, but tell me why I'm wrong.
Your Honor, if I could. I think that's the wrong approach for two reasons. First, this is, as we've been talking about, this is, I don't think the argument below, and I don't think district court counsel was asking for it, and I don't think the district court itself saw this as the defense wanting to put in just, you know, just the few, you know, cherry pick the facts. This is what's good for us. This is what we want to come in. And in fact, the district court said, I think when it was ruling on the motions, and I'm reading here from my notes, but if the defense argument is, if the court's inclined to allow the statement in, the jury needs to understand, oh no, I'm sorry, the defense requests that in the alternative to suppressing, I let everything in and give a limiting instruction, telling the jury how to find the court's polygraph unreliable. So yeah, we are asking for everything to come in. That's what we want. We want the jury to look at everything and to make a determination about whether or not this confession is believable. That's what didn't happen here. The second response I have is that if this is opening a Pandora's box, it's the state that opened the box. They did not need to rely on this polygraph coerced confession to convict Johnny at trial. They had other evidence. They didn't have to try their case this way. And to the extent this creates difficult evidentiary problems, the solution to those problems cannot be to strip Johnny's right, his constitutional right under Crane versus Kentucky, to present a complete defense. So is this the world's, is this the defense that you would pick if you could pick any defense in the world? It probably isn't. But the reality here is that Johnny has to choose between not challenging his confession, which puts him in a virtually impossible place at trial, or taking the risk of letting the jury see how the sausage is made. And this is a case where Johnny wanted to take the risk of letting the jury see how the sausage was made. And Crane v. Kentucky says he needs to be able to do that. The jury needs to weigh that defense. And if they're going to find him guilty, they need to find him guilty because they believe his confession was accurate in spite of the tools that law enforcement used to extract it.
Doesn't the whole universe of case law that says polygraph evidence is prejudicial to the defendant, doesn't that whole universe of case law essentially make the state's harmlessness claim here a slam dunk? That, hey, even if the defendant had got what the defendant wanted, it would have helped the state. There's no way that the defendant can demonstrate beyond a reasonable doubt that the outcome would have been different.
I disagree, Your Honor. There are true traditional rationales for keeping polygraph evidence out. One is that the results are unreliable. And here that was Johnny's whole point. The whole point is that they used an unreliable test to convince him that he needed to confess. You bombed this polygraph. We know you're lying. This girl needs closure. You need to confess. So the polygraph's unreliability is the point that Johnny's trying to make. The second reason we typically keep polygraphs out is because they usurp the role of the fact finder. Now this machine is finding out who's telling the truth instead of the jury making the determination of who's telling the truth. We want everything to come in precisely because the jury needs this information to make a fully informed decision. Without hearing about how this confession came about, the jury can't decide whether or not it's credible. In the same way that, we were talking about buying McDonald's for the co-defendant earlier. If the jury doesn't hear that that's what happened, and that's why somebody confessed to a crime, they have no way, they don't have the universe of facts they need to make a credibility assessment on that determination. And that is all that Johnny is asking for here, is to let the jury see everything, weigh the evidence, and decide whether or not they believe it.
Would you comment on the third issue and the harmlessness on that? Or were you going to?
I got a little bit sidetracked. I was hoping to get there.
I know you did, but yeah, go ahead. And comment if you will.
But yes, I guess what I'll say is if this court has doubts about the harmlessness of that confession, watch it. This was a 2 Kleenex box confession. It went on for nearly an hour. Johnny described in some detail an offense committed with his granddaughter. He described in detail a suicide attempt based on his guilt and his shame resulting from that offense. He described himself as a monster. And if you watch that video, I don't see any way to disregard the very real possibility that the jury in this case would have been intent on punishing Johnny for what he did in an unrelated case. And I do not see how that error can be harmless on its own, and particularly when coupled with the polygraph error and with the amended complaint.
If we agree with that, what do we do with the Court of Appeals assumed error? We have to send it back to the Court of Appeals.
No, Your Honor, because this court's rules say that when the Court of Appeals assumes an error without finding it, it's on the aggrieved party to cross petition or conditional
Really?
cross petition.
Okay.
And that didn't happen here. So our position is.
We have a
the-
rule on assumed error.
Well,
as
I
opposed to
can,
found error.
I think I've got the text of the rule here somewhere, but my memory is that it says.
May be right. You may know the rules better than I do. I'm
Ah.
sure you do, actually.
If the Court of Appeals assumes an outcome on an issue without deciding it, the conditional cross petitioner must raise that issue to preserve it for review. So it's our position that the state has waived that argument at this point.
Circling back, I'm sorry, but I know that she's trying to keep us on track. But in response to your last response before Justice Deagle asked on the prejudicial impact of this prior video confession, the jury, so I want to hear your answer to the jury did acquit on one of the two counts. So it doesn't seem like a video that otherwise talked about him being a monster and all this prejudiced them because they were able to put that out of their mind and find him not guilty on one of the two counts. Seems like they would have done a home run on this or not.
Well, I don't think we can say that with a constitutional level of certainty because we do not know what was going on in that jury room. Maybe what was going on in that jury room was, well, we don't find these offenses to be proven beyond a reasonable doubt, but darn it, we want to punish this guy, so let's hook him up on one. And we just have no way of knowing that that's not what happened, Your Honor.
Questions? Or anything in conclusion?
No, Your Honor. Thank you.
Thank you to both counsel for your arguments this morning. The court will take this matter under advisement. The court will now be in recess for 15 minutes.
The Honorable Justices of the Supreme Court. This court from recess now sitting.
Please be seated. Mr. Shima, would you please call the final case on the morning docket?
Thank you, Your Honor. May it please the court. The third case on the docket for Tuesday, March 29th, 2022 is appeal number 124587 in the matter of Michael P. Jan, original action and attorney discipline, no briefs filed.
Counsel, would you please come to the lectern and state your appearances?
Chief Justice Luker, members of the, or justices, Kathleen Selsler-Lippert, Deputy Disciplinary Administrator on behalf of petitioner, present and ready for argument.
May it please the court, Arthur Chaikin, law firm Kenny Hertz Perry, here on behalf of respondent.
Counsel. Lippert, when you are settled and ready, you may begin your argument.
Request permission for 3 minutes.
3 minutes granted.
Nature of the case in re Michael Jan is an original action involving attorney discipline. The case before you today represents an agreement by the parties to present to you pursuant to Rule 223, a summary submission. The case before you represents an agreement by the parties that the respondent violated professional rules of conduct. This case stems from the respondent's representation of his fiance. The respondent's fiance was a teacher in a private school in Nebraska. The school did not extend an additional year contract. She believed it was based on discrimination and asked her fiance, the respondent, to represent her in that matter. The parties have agreed the respondent's conduct in that representation of his fiance violated rules of professional conduct, Rule 1.2 scope, 1.7 A2, substantial risk of representation that will be materially limited by the lawyer's personal interest, 4.1, false statement of material facts, 4.2, communication with the represented party, 8.4 C, conduct involving dishonesty, fraud, deceit, or misrepresentation, 8.4 D, conduct prejudicial to administration of justice. The
Counsel,
parties.
I'm sorry, before you get too far into the facts, I did have one question on the agreement under the rule for the submission of these agreements. I don't see the aggravating and mitigating circumstances. So I was hoping that you might identify what you think those should be as you're talking about the facts, or now, whatever is more convenient to your presentation.
Yes, Justice Wall. This summary submission was submitted in September, just shortly before the Rule 223 was modified to incorporate that requirement of aggravating and mitigating circumstances. And the parties do have an agreement that we are prepared to discuss with the court today. Specifically with respect to that, the parties agree and ask this court to accept the agreement that the aggravating factors in this case are prior discipline and multiple offenses. The parties agree and stipulate that the mitigating factors applicable to this case are the respondent's personal and emotional problems that contributed to the violations, his attitude of cooperation and remorse. The respondent was originally licensed in 1997, but he was not in practice or did not have an active valid license for 14 years. So the length of practice really doesn't neatly fall into either aggravating or mitigating. It's just because he didn't have a license for 14 years. Based on the stipulations and the agreements, the parties are asking this court to consider or impose a 6-month suspension, which is commensurate with the ABA standards. The parties are asking this court to that the first 3 months of the suspension be implemented, that the second 3 months be stayed, and that the respondent be placed on 1-year probation with terms and conditions, including that the respondent participate in KLAP monitoring, the respondent participate in the KLAP law practice management program, that the respondent have a peer mentor and also a KLAP practice monitor. The respondent, or the goal or the purpose for the suggesting this probation is the respondent, as noted, was out of practice for about 14 years. And his time in practice was essentially working for Social Security Administration as I think an opinion writer. He has not previously been in private practice, and he anticipates going into private practice. The hope and the goal and the purpose of this probation plan, once a suspension is, the second half of the suspension is stayed, is to give him tools to be successful, to practice within the bounds of the professional rules of conduct that every attorney is expected to practice in. So that is the goal of the probation after a term, after he serves a term of suspension. The parties present this as an agreed stipulation to facts, rule violations, and sanctions, and ask this court to adopt and incorporate the sanctions as presented by the parties.
Can I ask a question about some of the factual underpinnings on the violations on 4.1A? It appears to me that one of the facts that has been proposed to support that violation is the fact that there was a request for attorney fees, but the representation was pro bono. And my understanding from the case law is that under federal discrimination statutes, a prevailing party can recover fees even in a pro bono situation. So with that being the case, in light of that case law, why does that fact support the violation?
In this particular situation, the demand letter that the respondent wrote and tendered to the school president on May 15th, the statement to that school president said attorney fees to date are, and the number that he provided in his letter as attorney fees that have already been incurred or involved was $25,666. So that is the statement that the respondent made to the president of the school, knowing or having in writing the retainer agreement, where he says, I think that retainer agreement is about 14 different paragraphs long, and I think pro bono is listed in about 11 of those paragraphs.
Right, but there's no factual basis to say that the amount of the fees didn't reflect the work that he put into that date, or did it? Are you saying that number was inaccurate? Let's say, forget there's a pro bono. If this was just an ordinary hourly engagement, was the number that was provided inaccurate?
As part of the case development, the respondent was asked to provide documentation of his hours or time put into this. The respondent was able to provide some calendar entries for some hours. I would describe it as sort of polka dotted around the calendar. The respondent also very clearly said he didn't keep track of his time because he knew it was going to be pro bono and didn't intend to charge anything, so he didn't really keep track of his time.
And then the only other question I had on the facts are the request for opposing counsel to reconsider the disciplinary complaint. That's a fact, as a factual basis for 8.4, I believe. Is there a time when it's appropriate for an attorney to engage in that sort of dialogue with a complaining party?
I would submit to you that the answer to that is no. And that is the underpinnings of the prejudicial to the administration of justice. The disciplinary administrator's office is tasked with receiving complaints from whoever might have a complaint against a licensed attorney, investigating those and then pursuing based on the investigation and what evidence is available in a case. Even if the complaint is withdrawn, our duties as investigators and self-regulating profession are to continue and to make that determination based on the facts of the investigation. There are a couple of cases with respect to that issue. So for instance, in Repile 278, Can 230, 2004, that case stands for many different things. Among them is that in that case, the respondent wrote a threatening letter to file a disciplinary complaint in order to gain leverage in a civil case that he was involved in. And the court talked about, and there are other cases where this court has held that threatening to file a disciplinary complaint is a violation or adverse to the administration of justice. Likewise, because attorneys have a duty and responsibility under 8.3 to report misconduct. And so with that duty, trying to convince somebody not to fulfill that duty is adverse to the administration.
But what if they're right? What if, I'm not saying in this case, but hypothetically, if an opposing counsel files a complaint and misunderstood the factual basis that led him or her to do so, why can't the respondent reach out and clarify the facts that may have led to the report to begin with, especially if your office is going to investigate whether or not that's been withdrawn, whether or not the complaining party has withdrawn the complaint?
The conduct of asking to withdraw the complaint doesn't alleviate, as you pointed out, our duty and responsibility to investigate, but it is putting up that or attempting to put up that barrier to withdraw and eliminate that. This court does have, there are cases in this court where respondents have conditioned maybe a settlement or returning attorney fees or some other type of settlement on withdrawing a complaint, which has also been held by this court to be adverse to the administration of justice. I believe one of those cases is the Kenny case, 289, Kansas 851, 2009. Some cases from other jurisdictions have talked about that prejudice under Rule 8.4D is measured in relation to the administration of justice, not any particular outcome of the parties. And that would be In re Ramirez, which is an Indiana case, 853 Northeast 2nd, 121, a 2006 case. So the duty to report, the duty to investigate, it's a self-regulating profession. And that duty to respond to a complaint, that assuming that a complaint is meritless, because people complain for good reasons, they complain for bad reasons, they complain for no reason at all, which is the point of an investigation. Also, the built-in safeguards and due process with respect to the review committee and the different layers of review. That is the opportunity for a respondent to put forth why a complaint is meritless, not asking the complainant to drop it. It is absolutely gut-wrenching to get that gray letter from the disciplinary administrator's office that a complaint has been received or being investigated. But your duty and responsibility under the rules is to respond to the disciplinary administrator's office that that complaint is meritless, and here's how and here's why.
Thank you.
May it please the court. Of course, we join with the disciplinary administrator in asking the court to abstain or accept the disciplinary administrator's recommendation.
I interrupt. I'm sorry. I know you had to move the mic away. Could you move the neck of it back
Yes,
and speak more into it? Thank you.
right. Let me start over, Your Honor.
Thank you.
My name is Arthur Chaikin. I'm very happy to be here before the court today on this very serious matter. As I said, we've stipulated to this summary disposition, and therefore my role at this point is to generally support the summary disposition, or at least nothing more severe than what's set out in the summary disposition. I do think that the court has raised some questions about what I would call some of the additional elements that are in the summary disposition, because this is essentially a Rule 4.2 case. It's because of the Rule 4.2 case that matter that the complaint by Attorney Flood in Nebraska was presented. And that is really the gravamen of this matter. A lot of the other elements, again, it's a stipulation. We're not running away from any of them, but one could say that they were added on to or grew out of the issue that was the Rule 4.2 problem. I would like to point out a few my opposing counsel, and it's a little odd to say opposing because we're sort of on the same side here, but Ms. Lippert commented on the issue of mitigation, which I think is a very important element in this case. Although Mr. Jan was admitted to the bar of the state of Kansas in 1997, he did not go into the practice of law immediately. For several years, he did not practice law. He did other work generally unrelated to the law. It wasn't until about 2002 or 2003 that he began to work at the Social Security Administration. And he did work there for about 15 or 16 years. That experience, I think it's important to recognize, was not the private practice of law. And although I've worked in a lot of different elements of the legal world in a lot of different contexts, and it's certainly enriched my career, I know that there are a lot of important differences between being a law professor, which is something I've done, being an in-house counsel, which is something that I've done, and being engaged in the private practice of law. It's not that the private practice of law is necessarily more difficult or challenging than other types of practice that one might engage in, but it is true that there are elements of that practice that require mentorship, experience, and a certain degree of resilience that has to be built up over a period of time. I consider myself very fortunate in that when I came out of law school, I joined a firm. And I was surrounded by people who were very anxious to teach me what it meant to be a lawyer and how to operate as a lawyer. And honestly, I've had those people throughout my career. And as I've gotten older, I've tried where plausible, where appropriate, to play that same role. Mr. Jan has never had that kind of mentorship in the private practice of law, never. He went from being admitted into practice in 1997 to going to only doing something legal related, law related when he got to the Social Security Administration. He was there for right up until 2019 when he had his Kansas license reinstated, and he had not been practicing law at all when he went up to Nebraska in 2019. He was contemplating practicing law, but not in the field that is the subject of this case.
Counsel, can I
Yes.
just, sorry to interrupt,
No,
but
it's okay, you're.
in terms of the aggravating and mitigating circumstances in this case, do you agree with opposing counsel as to that there is a stipulation, or at least verbally or orally today, as to the 2 aggravating circumstances and 3 mitigating circumstances she identified during her argument?
Yes, Your Honor, we do. The record is accurate. However, I think it's important to contextualize it because although I agree with Attorney Lippert that these are aggravating circumstances, it's not a bimodal element of, let's add up the baskets and see who's ahead at the end of the game. There are some of these elements that, although aggravating, when viewed in context are understandable. So for example, the multiple offenses is a mitigating circumstance. But as you pointed out, Judge Wall, some of those elements, like the concern about accuracy in some of the statements that were contained in some of the documents that were provided as part of the investigation, in context, those misstatements were not impactful or deceiving. One could argue they were deceptive from the point of view of the disciplinary administrator's office in that they were not accurate when made. A great example of this is the one you raised, that, at the time, he wrote to Scott Catholic School and said, here's what my fees are. He was basing that on a computation of an imaginary damage claim and a contingent fee based thereon. So from the point of view of his conversation with his clients' understanding of what he was doing, and certainly from his perspective in terms of what he was presenting as sort of an opening effort to set out a position. And as you all know, a lot of times in a first go around, an attorney will set an aggressive first offer. That's really what he was doing. In terms of the hours he had in, if you want to look at it that way, in the case at that point in time, it had the potential to appear to be inaccurate and deceptive. Another example of that is, and it's in the record, Mr. Jan wrote an agreement with his client because he was actually concerned about this representation. It was not his chosen field. He had some reluctance about it, but he was trying to find a way in his limited experience to put some limits on the representation. So he wrote, like a lot of us do, he attempted to write a limited representation agreement. And in that agreement, he said that this would be a pro bono matter. He also said that he was admitted in the federal district court for the District of Nebraska. At the time he wrote that, that was not true. And it had the potential for your run-of-the-mill client for that to be deceptive. But his fiance knew exactly what his status was with regard to the federal district court for the District of Nebraska. So taken in context, although one could say that this was a problematical issue with regard to the investigation and to the overall package of information provided to the disciplinary administrator, it really was information that had the potential to be deceptive, but in context, it really was not.
Why was it put in? Why was it put in the retainer agreement?
That he would be
The
yes.
specific information that was false about holding a license.
I think my client was trying to be extra careful to assure that he was making a record that he was not admitted in the state of Nebraska, because he was also trying to limit his representation, and he did in that same document, to say, I won't be doing any litigation for you. He, in his mind, and your honors, I understand that this is not the way the ethics laws actually work. But I can tell you, because I do a lot of work in the intellectual property area, there are a lot of attorneys who practice federal trademark and patent law who think that as long as they're doing that, they don't have to worry about where they are admitted in which state. There was, of course, that famous Supreme Court case where the US Supreme Court said, patent lawyers, if you're practicing patent law and admitted to the patent bar, that's okay. But that case has really caused a lot of confusion, because there are a lot of attorneys walking around thinking, as long as I am practicing federal employment law or federal trademark law or federal ERISA law, I don't need a license in this state. That's wrong. But that's what was in my client's mind when he was writing this retainer agreement, and why he was trying to be very accurate
But
about.
it's not, I don't understand you just said a minute ago that both he and his client knew that it was a false statement.
Right, and I didn't get to the punchline.
Okay.
But the punchline was, he told her, so I won't be doing anything until I get my admission from the Federal District Court of Nebraska. And indeed, that's what happened. He did nothing on behalf of the person we refer to as SD until he was admitted in the Nebraska Federal District Court.
So you're saying it was essentially a preemptory statement of an anticipated fact. Is that
Yes,
a fair
Your
way to
Honor.
say it?
Yes.
Okay.
I see my time is starting to run down. I think I've contextualized the elements that I wanted to put into context. If there are any questions from the court, I'll take them, but otherwise I'd be happy to give you a minute and 20 seconds back.
But what's his plan going forward? I mean, part of what we have to do is look ahead and to make sure that public is protected. So I think we need a little more context there.
Yes, Your Honor. Well, we've worked hard to find some helpers who will be involved with Mr. Jan during his period of probation. One of them is Samantha Shepard, who is a very experienced elder law trust and estates lawyer in Kansas. She's has her own law firm. There are several other attorneys there. She's going to be his probation monitor. And then there's Mr. Smith, who's going to be his attorney mentor that was made available through COLAP. Mr. Jan has not yet decided what his future path in legal practice is going to be. But I think, and I see I just ran out of time. Can I have thank you. But I think one thing he has learned from this very difficult situation that he's been through is that he needs to be much more careful about the clients he works with, specifically that there is additional dangers when you work with a client who you're very close with. It's hard enough working for a client because you do develop a relationship with your client and you want to do, you want to please them. You do. You want to do what's right by them. But it's more difficult when you have a personal relationship. But I also think that Mr. Jan has recognized the importance of mentorship and will look for that. I do think if he goes back into the private practice of law, it'll be in the field of trust and estates and not in employment law, which was never in his mind. Mr. Jan is an expert on Social Security rules and Social Security law, but he's not an expert on employment law at all.
Are you comfortable sharing Mr. Smith's first name?
Yes, I think it's Brian Smith. I'm sorry. Thank you, Your Honors.
Reserve 3 minutes.
Members of the court, the probation is designed to hopefully provide the respondent tools to go forward so that violations do not happen in the future. The facts supporting the different rule violations are set forth in the summary submission, primarily on pages 17 through 20. The false statements to others focuses on his 5/15 demand letter, which had a false address for the respondent, said attorney fees to date are in excess of $25,000. In that same demand letter, he talks generally about the prospects of settling and the costs of litigation and some of those different things. But the third aspect or violation of 4.1 false statement to others is the email that the respondent sent to the opposing party, the president of the private school, on July 26th, which attached a proposed settlement agreement. In that email, the respondent said to the party who was represented, attached, please find this settlement agreement that's, and implied it was a result of consultation with opposing counsel, which was not accurate. So that is the additional false statement there. It was actually unilaterally and significantly modified by the respondent. With that, I would stand available for questions, but I also want to give time back if there are not additional.
I have a quick question.
Yes.
In cases involving dishonesty, like you've just laid out, typically a 90-day suspension would be considered a light. I realize I'm speaking in the generalities, but we heard opposing counsel contextualize the stipulation, but you just kind of came up, and it strikes me as that you uncontextualized it. So as I read the stipulation, like it speaks in pretty blunt terms about making false statements and essentially committing fraud. And then I see, and we're asking for 90 days, and I can't quite make those things line up.
Your Honor, I think that a 90-day suspension is appropriate. This case this court has made very clear that you take a look at each case individually, that you personalized. I'm not, that's not necessarily the words that you have used in case law, but you craft it for the specific facts,
Well, in light of that,
circumstances.
would you agree with what your opposing counsel again described as a contextualization of the stipulation?
I think there are contexts. The respondent absolutely was trying to do a favor, help his fiance, was committed to being helping her in what was very emotional.
I'm sorry, I'm interrupting you. I know, I'm sorry about that, but it strikes me that, and we have this, I at least have this problem oftentimes when we have these discipline cases where it seems like folks want it both ways. Like it can't be that he both committed fraud in an attempt to extort money in violation of the rules. And it was kind of an accident. He was trying to do people a favor. Like both those things can't be true. So I'm just trying to drill down to say what's the real story.
I guess for some case law context support, this court has looked at attorney disciplinary cases where there have been conduct involving knowing, intentional dishonesty, fraud, deceit, in Betts, which is 289 Kansas 820 2009, intentionally created or altered an insurance card to appease his wife. In that case, I believe, resulted in a public censure. And this court has also very much, with respect in the Stockwell case, talked about how you can't really supervise the fraud, dishonesty conduct, but has also recognized, I believe it was in the matter of KNOPP, K-N-O-P-P case, where the court appreciated that the misrepresentations are not all created equal, and some turn out to be more or less consequential depending upon the surrounding circumstances. And in the COP case, they imposed a 90-day suspension. They actually stayed that suspension and imposed discipline. In this case, the parties are asking this court to impose a discipline, implement 30 days of it, stay 30 days, place him on probation.
Did you mean 3 months and 3 months?
I'm sorry. Yes, I apologize. I misspoke.
That's right.
Terribly there. 3 was in my mind. It's, yes, 3 months. I'm so sorry.
Oh,
I have a question, if I may, Chief. Did respondent ever directly say to the president, who was represented by opposing counsel, did he ever directly say this has been agreed to by opposing counsel? Or did he just present it stating that they had talked about it?
I'm looking for my your attorney and I have been in consultation about a settlement between the school and the client pertaining to her employment discrimination suit. The document releasing the school is attached to this email. Please sign the document and send it back to me so I can pass it on to my client. And that is in volume 2, Bates stamp page 59. So it was implied that the attached document is a result of the consultation between the two attorneys, which it absolutely was not. A draft had been sent to the respondent. That draft by opposing counsel was significantly modified, unilaterally modified. The respondent didn't return it to opposing counsel. In fact, he'd had an email communication shortly before then indicating that, yes, he had some thoughts about the draft. He was busy, needed a few days, and he would get back with his thoughts on it. But instead of getting back to the opposing counsel, he sent it to the represented party.
was there some evidence in the record that it was not actually him that sent it to the president of the school, but that
So the evidence in the record reflects that the respondent and his fiance were sharing an address. And there is, I believe, an affidavit from the fiance that says that she was there with him when he sent it. And she believed it to be appropriate. I'm paraphrasing a little bit there, but the evidence has been that he sent it to the school president. I want to call it principal, but it's president.
Clifford, do you have an objection?
Justice Dandridge, right, he never explicitly said, this is the agreement that was sent to us and we're signing it just as it is. And Justice Daigle, there was no money for anybody in the settlement agreement. The truth is, the changes that were made, and it's in an affidavit that was filed with the panel. Respondent's fiance was in a very fraught and highly emotional state at the time that all of this occurred. And respondent did not want her to change that agreement. That's also in the record. It was actually, and I have to say specifically, my client has taken responsibility. He's not saying, oh, she did it, not my fault. But it was respondent's fiance that made these changes and then asked respondent to send the agreement. If he had said, I'm not touching this, and she had sent it, we wouldn't be here right now. But he sent this agreement. There was no money in this for him. So the mitigation here is that it was an extremely fraught, emotional situation, to the extent that my client was concerned about his fiance and her well-being. Again, that's not an excuse, it's a context, and that's all I wanted to add.
Clifford, anything else?
Only if there are questions.
Thank you. Thank you to both counsel for your arguments in this matter. The court will take the case under advisement, and we will be in recess until 9 a.m. tomorrow morning.